So I do have a presentation to take me through this presentation, a visual presentation. Good afternoon, everyone. Thanks for being here. Funnily enough, I think this gentleman just stated my conclusion very emphatically. So I'm going to continue plugging away at what I think is a point I'm fully in agreement with him on, which is that the right to privacy as is currently conceptualized, both in the draft legislation and other variants, including variants that are involving civil society, judgments of the Supreme Court, just doesn't break free of a conception of privacy as involving commercial transactions, right? And starting off from a point of somewhat strict criticism, I think the most lauded literature on the point in India seems to be the Justice Shah committee-led sort of report of the expert group on privacy, and I mean, I finally had a chance to go over that somewhat carefully last evening, and I was fairly shocked to see that each and every country and each and every parallel legislation that was examined torn free of its constitutional moorings, right? So when the Shah Committee and the group of experts look at the European Data Protection Regulation, they forget that it works within the European Convention on Human Rights, the UDHR, customary international law pertaining to privacy. When they look at Australia, when they look at New Zealand, when they look at the US, in each of those contexts, the constitutional basis within which more recent initiatives have been made to deal with a particular commercial element of privacy has been ignored, right? So my first thought was the report of the expert committee didn't really do justice to those terms of reference, right? And disturbingly enough, I see the same lapse featuring in current efforts to get a privacy bill out there on the books, the laws of India, as soon as possible, because you know it's a scary situation. We have a surveillance state out there, so might as well make a law, right? So that's my first point of sort of critique on where things stand, okay? And most of this brief presentation, I am going to try and limit myself to 20 minutes, is sort of an effort to clarify the political economy within which initiatives to move law towards a particular endpoint finds itself, right? So I want to talk a little about what's the sort of moving force behind a particular direction that the privacy legislation takes. I want to highlight how any sense of privacy in India will have to open the debate to much bigger questions of dignity and liberty in the Indian constitutional sense. And finally, going with my posture for rather abstract thinking that hopefully leaves questions rather than provides answers. I also want to get you to think about whether the Indian idea of privacy, and I use that word very consciously, the Indian idea of privacy can be premised on a liberal, individualistic, rational, private-public separation and a continuous transition to a glorious future mode of thinking about our place in the world, right? Because I think there is some space within our constitution and within the statutes that we have operating in India today, and certainly within some of the more enlightened judgments that our Honorable Supreme Court has provided for us. There is some space to think of India as a country that hasn't sort of bent over for Locke, right? There is a possibility that Rousseau and his sense of a community existing before private zones of liberty, that space does exist when we think of legislation such as just to give you an example, the rights of traditional forest dwellers and what that does to our notions of private property, right? So this isn't the nature of a conversation. I can't claim to have very clear answers. My hope is to give you rubrics within which one can think of privacy in the context of the two other big terms on that banner behind me, free speech and surveillance. And the quote that you see on the very first slide, to a certain extent, I think nicely captures how most of the world feels about privacy today, right? That is, for manifestly, you've long been aware of what you mean when you use the expression being. We, however, who used to think we understood it, have now become perplexed, right? And when you sort of replace the we or the being with the Indian citizen, or the Indian tribal woman, or the raped Indian tribal woman, or the raped Indian tribal woman who is fighting for a paternity test for the son that's born as a result of that rape, that fragmentation of this unitary idea of citizenship does sort of locate itself within the debate on privacy, right? Again, sort of given my stated desire to sort of be a little skeptical about the current effort. Could I also move to the next slide? To be skeptical about the current effort relating to a privacy legislation in India, I think it's important to ask sort of upfront sponsors of the conference today, FICCI, how much are they influencing the discourse on privacy in India, right? Is that the reason why the bill that was initially announced in 2010 and that organizations such as the one that the next speaker represents are promoting in a participatory manner today, is that the reason why there seems to be a particular focus on proceduralities and techniques of restraining powers that be without opening up the larger question of what is possible for privacy, given that we have such a beautiful constitution and given that that constitution 60 plus years later has shown us that it's resilient, has sort of come through the storm, so to speak. There's a long way to go, of course, not sort of discounting that, but the Constitution itself is not a carbon copy of another Constitution. The Constitution itself continues to allow us as Indians to discover its constitutionalism, right, in a myriad different ways. So that's something I'd like to get all of you who are thinking about privacy in India to think about. That is, what does corporate India have to gain or lose by privacy, right? And my point is not a polemic against FICCI. It's one of the most substantive points I'll be making today. I think much rather than enjoy sort of armchair theorizing in air-conditioned rooms, an empirical analysis of who wins and who loses in different privacy contexts is a key exercise to be completed before one begins to come up with a law on privacy, right? And I'll just detail that in a short while. So that's what got me thinking about privacy first. That is, why do I work with privacy and why am I fascinated by privacy and technology and informational privacy? That is, there's something about the informational realm that really queers things up, right? There's a possibility of mutation, there's a possibility of replication, there's a possibility of schizophrenia, there's a strange vulnerability, as I saw in the newspaper just yesterday, of your Facebook account committing suicide. There's something about our informational personality that is both frail and not limited by the physical constraints that are non-informational, non-electronic. In the real world, flesh and blood personality is sort of consigned to live within, right? And I think that possibility brings with it the that factual situation brings with it the possibility of thinking of a law that indeed operates with, as I say, a greater intensity of spirit, a more human approach to time, and a clearer claim to reason guiding actions, right? And I think the only sort of phrase that requires clarification is a more human approach to time, right? As J.S. Mill pointed out famously in his book on representative government, an enlightened despot who would all hours works perfect would be great, but practically that's not possible. He just can't be everywhere at the same time. The nature of the informational world and how information occupies particular circuits and the possibility of our surveillance technologies today allows for the time and distance factor to be circumvented. And I think that's not only a bad thing, that there is some great promise for what law can do in this realm and perhaps inspire in other realms as well. Could we please move to the next slide? Right? And a sort of distributional effect of privacy protections throws up surprising results. Right? Just think for a moment, that is, if you have really good, nicely drafted, fairly comfortable EU approval stamped laws relating to closed circuit TVs, CCTVs in India, who gains? Right? The sort of naive response would be, we the people gain, CCTVs are finally controlled by law. A simple empirical analysis of the sales relating to CCTVs will tell you that those who sell CCTV technology really gain from the existence of that privacy protection, right? That's just one sense in which a privacy law has a particular winner and has a particular loser, right? And that's the broader context in which it's useful to think of, if we have the Privacy Act of 2013 in a particular form, who gains from each of those protections, right? You must have a particular level of security, you must obtain consent, you must intercept only in so and so manner, intermediaries must do so and so, right? There's, I would suspect, a whole sort of nebulous zone of operators that have huge commercial gain, right? From laws that will say that merging of databases is allowed, let's say, between banks or between health insurance companies, as long as these requirements are put in place. Right? In terms of actual rupees and dollars, it's not just the people, there's a clear corporate interest that also gains. Right? Again, to sort of comfort you, I'm not attacking the corporate sector today, but in a particular context relating to paternity, right, or DNA testing to establish the legitimacy of a child. It's no longer as simple as the people gain from the existence of a law which says that the court can order a DNA test to determine who the father of this child is, right? There's the father who is perhaps reluctant, there's the mother who has a particular interest in the test coming out a particular way, and as you're all familiar, there's the best interest of the child that requires something as well, right? And then of course the court, so on and so forth. So the first point is spend some time carrying out a positive evaluation of privacy law, and then get back to your normative ethical theorizing, and that will be both eye-opening and very, very valuable in clearly defining the contours of your rights, entitlements and duties. Right? And I'll just sort of briefly return to how we can sort of problematize that more specifically in the Indian context. The second point, I think, is where the big elephant in the room is. That is, when I think of privacy, where do I focus my energy, time, money and attention, right? Do I focus my energy on the abstract nature of the private person? Do I focus my energy on the technology itself? Do I try and embed a privacy by design kind of concept, right? Many of you all who've worked on privacy might be familiar with what South Korea did and India tried to do. That is, every time a mobile phone takes a picture, the actual light must flash, or a recording of a shutter must play from the phone, so that voyeuristic pictures are minimized as much as possible. Right? So do I embed that in the technology itself to ensure privacy? Do I focus on who the private person is? Right? This question is not trivial. Right? I think it's a clear answer on this, and I don't have a clear answer, because I think what the Privacy Bill of 2010, 2011 and the CIS Privacy Bill, which I hope many of you all have seen and hopefully participated in, they sort of mix both these efforts as I see it. Right? They also focus on who is a private person in terms of what are the constitutionally exceptions, okay, security of state or investigation of a crime, that in a way is limiting constitutionally or in a fundamental law sense what the limits of your privacy are. But they also focus on just the techniques, the proceduralities, the requirements of data storage for a particular period. So that's a pretty important question to, I think, unpack and have some clarity on. Right? Before I move on, Strahilevis also makes 4 interesting assertions about surveillance. Right? First, he asks you to recognize that surveillance definitely has 100 good things about it. Right? You can prevent a disaster such as Uttarakhand. You can organize your food supply in a better way. You can ensure that money is not wasted when resources are available. You can allow for better spread of knowledge about health, so on and so forth, only by the state, in fact, treating its citizens as populations and collecting statistics about them, right? As Michel Foucault most famously articulated in his essay Governmentality. That said, Strahilevis, I beg your pardon, leaves us with 4 sort of take-home lessons on surveillance, right? One, that surveillance that is secret is illegitimate. You can't have secret surveillance, right? You can have surveillance that affects your right, but you can't have surveillance that's entirely secret. Okay? His second assertion is that surveillance that is total is also illegitimate. His third assertion, and I'm just quickly running over them, is that surveillance in its present form transcends the private-public divide, right? It's no longer just about the government or just about media corporations. Whichever way you look, they're all implicated, we're all implicated. And just to sort of rile my friend Raman, who's also here, I'd like to sort of bring the example of Google and virtual Alabama, right? Where through spatial satellite mapping that's plugged into every camera that exists in the city, you have something that is not even being recorded anymore, but it's constantly monitoring, constantly surveilling. So state, public, companies, private, universities, private, even CCTVs from residences, okay, all plugged into something fascinating that Google has built for good purposes, ostensibly, right? No, I mean that in a good way. Okay, so what do Daniel Keith Citron and David Gray, also on the same sort of slide, tell us about what I just outlined as being Richard's position? They say, I think he's got it wrong, okay? That is, Richards asks us to focus on intellectual privacy. Yes, privacy is implicated in so many ways, but the real privacy that should get us worried is when activities that sort of allow us to be intellectual beings, our reading, our writing, our thinking, our communicating, when those activities are threatened by intrusion, that's where surveillance is doing something wrong, right? And the best way for checking intrusions of intellectual privacy would be by litigants going to court, right? Because the government or the market, or usually the government market complex, is responsible for the intrusion of your intellectual privacy, right? And Daniel Keith Citron and David Gray say no. That's a slippery slope you're going down. Okay? So if you as a judge are trying to decide on what are the intimate areas of married life that the state can't intervene on, Citron and Gray point out that as a judge you'll never be sure. It'll always be your individual position, right? And as Justice Scalia in the 2001 Cruz case in the US, that's a position he took. He said, I can't really do this stuff. Who am I to say what is intimate married life for a zillion different American couples? What I'll do is I'll focus on the technology. And what is the technology? The technology is a fancy instrument that allows one to see inside a house based on, let's say, thermal heat patterns. Okay, I'm just giving you the rough frame of that. Okay, the last and final point, and this is to a certain extent my own speculative input on this, that is, where can we place privacy in the Indian context, and how can we begin to unpack this Heideggerian difficulty with understanding privacy, right? If at all we have to come up with a catch-all constitutional discussion, which is more than Karak Singh, more than Govind, more than Raj Gopal, more than even the NAS Foundation dealing with consensual sexual relations. If we have to have one position in our constitution, the meta key to privacy, what kind of analysis would be useful, right? And I just sort of take a speculative stance on that. Alright, so I'm going to skip. Okay, that equation there, which could you skip 3 slides ahead, please? Yes, the one you just passed. Right, so that to a certain extent, where I is the legal imperative at a time t, L is the law that applies to terrorists and non-terrorists, Q and K, and mu is the uncertainty existing in the system, which represents how privacy might pan out, right? A particular constitutional provision I that will ensure that privacy is fully respected and things don't go wrong at all will result in mu being equal to 0, right? And that's just one way you can map it. Yeah, can we please move? Please continue. Yeah. Okay, so winners and losers of privacy protection in India, it's not just about the privacy bill, it's not just about Article 19 or Article 21. There have been 700 cases, and my friend Prashant Iyengar, who's done some good work on this, has documented there have been 700 cases in the RTI forums across the country on the battle between privacy and transparency, or your right to information, right? So who's winning and who's losing, and what does that mean for the existence of that privacy right is something worth thinking about. For those of you all who studied civil or criminal law, okay, you have the rights to summon people, the rights to obtain saliva, spit, semen from a suspect, the medical examination of a rape victim, procuring of documents, all of that to a certain extent results in winners and losers based on privacy protections. Okay, privileged communications, lawyers, doctors, the fact that the Evidence Act won't allow those communications to be used or invoked in court, communications between husband and wife, again leads to a particular balance in the privacy game, right? So there's a whole host of areas, some of this is then the Shah Committee report as well, where privacy already exists in India and pans out in different ways for different people, right? So immigration, okay, foreigners, travel and borders, GNE, which I think our student introduced, the student who introduced the session did mention, cyber cafes, medical privacy, so on and so forth. Okay, banks, insurance companies. Can we move on? Okay, I think as the students who introduced the session did point out, the post office legislation and the telegraph legislation started fairly okay. Things went awry with the IT legislation, and the proposed privacy legislation, at least the first draft in 2010, continues to persist with that weakened approach to privacy. speculations for why that might be. I gave you the conspiracy theory, too much FICCI, but it's basically too much EU level trade, okay, and too much pressure from the European data controller to comply or lose trade, right? Section 43 of the IT Act is interesting because it finally allows the possibility of damages for loss of privacy. And the quick question I want you to think about is what would it be or what would it mean for India if Indians had privacy torts as actionable claims, right? If you could actually go to a specific tribunal that doesn't have a 10-year waiting list and get money for every time your privacy is violated. Yeah, so I'm just going to flag that thought, okay? Privacy as an actionable tort has some basis in the US, and there's a battle going on in Canada and Australia as well, right? So I think Ontario has accepted it very recently. Yeah, could we move to the final slide? Okay, so yeah, the very last slide, please. I'm going to, the second last slide on privacy. Yeah. There you go. Alright, so my sort of hypothesis, and this is something for your consideration, is that privacy rights, as we all enjoy them, simultaneously manifest in two ways. Okay, one sense is a property-based sense, okay, and that is a right that is subject to reasonable restrictions, proportionality, all of the stuff that we are trying to do in India today. The other sense, and this is the sense in which only the German Constitutional Court has been courageous enough to take a position, is that privacy also exists as a guarantee inherent in us, in a sense that Madhavi, I think, was alluding to in the morning. Okay, there's something about how we live as people together that makes privacy more than my liberal individualistic right. Okay? It's the very basis for our existence as our social community, right? And going with the German Constitutional Code, I would speculate that it's worthwhile to sort of scour through the Indian Constitution and try to see whether there is a core area that cannot be violated, right? There's a particular term there, inviolate private life sphere. If that's possible in the Indian context, why not, right? Why stick to the weaker limit? So that's my sort of final provocative position, and hopefully we can have some comments in the discussion session. Thank you. I think I've exceeded my time.